Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and this week's contract tip has to do with the question, can a seller terminate a contract if the appraisal comes in lower than the sale price? Well, the answer is no. Well, I take that back. The answer is yes, but they would default on the contract if they do. So let me show you in the GAR contract where we are talking about. So on the actual conventional financing exhibit in GAR, and that exhibit is F64, Conventional Loan Contingency Exhibit. It states the appraisal paragraph in that exhibit is paragraph 10, where it says specifically appraisal contingency. And the way that paragraph reads, basically the buyer has the opportunity to have the property appraised if they're getting a loan from an institutional lender, that the lender shall cause an appraisal to be performed, and the appraisal must be completed by an appraiser licensed in Georgia. And there is a time frame in there that the buyer and the seller negotiate when first going under contract. So within X number of days of binding agreement date, if the appraisal comes in low, the buyer has the right to request the seller reduce the sale price of the property to a price not less than the appraised price by submitting an amendment to reduce the sale price and a copy of the appraisal. If the buyer does not submit this amendment asking the seller to reduce the sale price, then this appraisal contingency is waived by the buyer, and the buyer is therefore obligated to purchase the property at the contracted price regardless of what the appraisal comes in at. So get that, remember, conventional loan, if the appraisal comes in low, the buyer must submit an appraisal to the seller. And again, there is a time frame that the buyer and the seller negotiate up front for this appraisal contingency to ask the seller to sell it lower. If the buyer doesn't submit this amendment, then the appraisal contingency is waived from the contract and the buyer is obligated to purchase at the price regardless of the appraisal price. So then the seller, so the buyer sends in the appraisal, the amendment asking for the lower sale price. The seller then can accept it or reject it. So, and there are time frames written in the appraisal contingency that all of this has to happen. If the seller accepts the amendment to sell the property to the buyer at the appraised price, buyer sends the amendment for the lower price. If the seller accepts it, the buyer is obligated to complete the purchase at this appraised price. If the seller rejects the amendment and does not agree to sell at the lower price, then the buyer has the right but not the obligation to terminate. The buyer shall have the right but not the obligation to terminate the agreement without penalty upon notice to the seller, provided that notice is given within 3 days of the earlier, and then there's time frames within that. Nothing herein shall require the buyer to seek a reduction in sale price of the property. In such event, buyer shall be obligated to purchase the property at this price set forth in this agreement. So low appraisal, the ball is still in the buyer's court. Just because an appraisal comes in low, the buyer sends an amendment asking for a lower sale price and the seller says no, the seller may not terminate. The buyer still has the right. The buyer can either terminate or the buyer may proceed. Now that's in the GAR conventional financing contingency exhibit. On the GAR FHA Loan Contingency exhibit, which is F63, the appraisal paragraph is labeled, it's paragraph number 10, the Amendatory Clause. And in that one it says, it is expressly agreed that notwithstanding any other provision in the agreement, the buyer shall not be obligated to complete the purchase or incur any penalty by forfeiting the earnest money if in accordance with a written statement by the Federal Housing Commissioner or direct endorsement lender set forth the appraised value of not less than blank dollars. And the buyer and the seller would have negotiated that dollar amount again up front when they were negotiating the contract. buyer shall have the privilege and option of proceeding with the consummation of the contract without regard of the appraised valuation. So basically, and there's no time frame for the appraisal contingency in the FHA contract, in the FHA loan exhibit. So what that means, couple things. Number one, because there is no time frame, the buyer is protected on the appraisal contingency rights through the last contractual day of closing. And if the property appraisal of the property by the FHA comes in lower than the amount you guys have filled in on that amendatory clause, the buyer may terminate the contract under no penalty. The seller may not terminate, but the buyer may terminate. Or the buyer may proceed, and of course they would have to pay cash for the difference between the appraisal amount and the contracted price. Or the buyer may propose an amendment to the seller. The buyer and the seller may agree to sell it for the appraised price. But again, any rights regarding the proceeding of the contract, they are in the ball is in the buyer's court, so to speak. Now let's look at the VA Loan Contingency Exhibit, which is Form F65 in the GAR contract, VA Loan Contingency Exhibit. And in this exhibit, the appraisal contingency, so to speak, is also called the Amendatory Clause, and it is also paragraph 10. And in this one, it's very similar to the FHA paragraph. The only difference is the buyer and the seller don't negotiate that price. You don't have to put in, there's not a fill in the blank for the price. So basically it says the buyer shall not incur any penalty or forfeit any earnest money if the purchase price or cost exceed the reasonable value of the property as established by the Veterans Administration. So basically, if the VA appraisal comes in lower than the contracted sale price, the buyer may terminate based on that low appraisal. And again, there's no time frame, so the appraisal contingency rights for the buyer go through the last contracted day of closing. Now, again, the buyer does have the right to proceed with the purchase even with a low appraisal by the VA, but the buyer will have to pay cash for the difference, or the buyer may terminate, or the buyer and the seller may negotiate to sell at the lower price. But the seller does not have termination rights. The ball again is in the buyer's court. So on a conventional loan, the buyer must propose an amendment. You must give the seller the option of selling it at the appraised price. VA and FHA loan, the buyer may choose to proceed, may choose to terminate, or may choose to negotiate with the seller to sell it at the lower appraised price. On the all cash sale exhibit, which is GAR Form F79, there is an appraisal contingency paragraph in there, paragraph 5, and when the buyer and the seller are negotiating the contract up front, you must determine if the contract is subject to an appraisal or not. And if so, those appraisal rights are similar to the appraisal rights for the buyer in the conventional loan contingency exhibit. So hopefully that helps you guys understand how the appraisals work when you go binding under the GAR contracts. It is all spelled out and written in the loan contingency exhibits. So thank you all so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.